Good afternoon and welcome. Today, we're going to learn about housing law, a way to ask your landlord for repairs, what to do to get your security deposit back, how long the eviction process takes. We're also going to talk about recent changes in the law, protections about rent increases or ending your month-to-month tenancy, and we'll share some resources about applying for rent assistance. We have a great panel for you today, a panel that gives a variety of perspectives on the housing world. Before we let the panel introduce themselves, I'm told we have some lawyers watching, and this clinic has been approved for CLE credit, so we'll share the CLE number at the end. We also should have some time for questions at the end. Please put those in the chat. Let's let the panel introduce themselves. Joe, please introduce yourself.
All right, good afternoon, everyone. I'm very pleased to be here today. My name is Josie Sesodia. I'm the Director of Urban Planning over at Broward County, and I'm also staff to the Broward County Housing Council. I am not an attorney, in the interest of full disclosure. So I'm looking forward to talking to everyone today about the changes that have happened here at Broward County and the new legislation that's been passed by our commission.
Thank you, Joe. Yes, we're looking forward to learning about the new ordinance and the protections it provides. Basel, please introduce yourself.
Hi, everyone. My name is Basel Zacur. I am an attorney, and I am the owner, I guess you could say, of the law offices of Basel Zacur. We do landlord tenant law, and basically, I'm thankful for Coast to Coast Legal Aid to have me here and help out with this CLE course.
Thank you so much. We're looking forward to learning about housing today. I want to start with some of the most common questions that people ask our office. And the first one is, the problems in my apartment, the stove's not working, there's a roach infestation. How do I ask my landlord to make repairs?
Well, the first step as a tenant is to communicate with your landlord. Statute says that you are to send what's called a 7-day notice to your landlord in writing, certified, so then that way he could actually receive notice. And basically in that notice, you explain what the problem is, and you explain that he has 7 days to make the repairs. Now, that doesn't mean he has 7 days to complete the repairs, but he has 7 days to at least get started on the repairs. Sometimes, for example, if the air condition's out and you have to order the part, you can't just make the repair within 7 days. So as long as he started, he called the AC guy, told them to go ahead and make the repairs. Okay, well, the part's going to come in another week. Then at the very least, they're in the process of repairing, and then once it's repaired, everything is done with. However, if he completely ignores the actual repair request, then at that point in time, you could withhold rent or make some sort of deduction on the rent because of the fact that he has not gone ahead and even tried to make the repair or even start with the repair.
And you sometimes see tenants who think they can just stop paying rent. You don't have to tell the landlord anything or give him any written notice. What would you say to a tenant who just stopped paying the rent and didn't communicate with the landlord about it? Does that work? That
does not work, because now you have basically a situation in which the landlord is going to serve you with a 3-day notice for non-payment of rent. And then basically, if you're going to bring up the fact after the fact, that, oh, well, this wasn't working and that wasn't working. Well, why didn't you tell the landlord? So, you know, I always recommend have an open line of communication with the landlord. Even if you texted him, even though I recommend that you send it to him in writing, like I said, but even if you texted him, you have some kind of defense. But once again, recommend that you send it in writing, certified, so that way you know he received
So
it.
that's the takeaway point, right? Got to demand these repairs in writing.
Yeah.
And to help you with that, I want to share our first great resource of the day. The Florida Bar, actually, the Florida Bar website has a link to a list of landlord-tenant forms. And one of the forms is actually the form to send your landlord if you're demanding repairs. And you can just open up this link. It's a fill-in-the-blank form, and it walks you step by step through how to send that notice. So we're going to put the link to this in the chat, and it's a great resource for you. Before we go on to our next frequently asked question, we have a very special panelist today. I'd like to let Judge Betsy Benson introduce herself and say thank you so much for joining us.
Well, good afternoon. I am Judge Betsy Benson. I'm in the County Civil Division here at the Broward County Courthouse in Central, and I happened to be in the middle of a landlord-tenant hearing and was unable to get here on time, and I so apologize, but it's an honor and a privilege to be here. Thank you.
Judge Benson, if we could send the next question to you, really a starter question for a landlord or a tenant who's just trying to familiarize themselves with the law, trying to figure out what the protections and rights are. Where do you think is the best statute?
Oh, that would be Chapter 83 of the Florida statutes. That really lays out in very straightforward terms what the responsibilities of the landlord are, what the responsibilities of the tenant are, how to prosecute an eviction, the right way to go about it, so you can try to efficiently handle the matter without having to go back to the clerk's office 3 or 4 times, and how to defend against an action for eviction.
Yeah, all the answers, a lot of the answers are in Chapter 83. And a lot of them really clearly spell out exactly what the rules are, exactly what your rights are. And that's a great place to look for any questions you have. Basil, next really common question that we get from our office is, how do I get my security deposit back? Do I get it back the day that I move out? Does the landlord hand it to me when I give him the keys?
Well, that's up to the landlord, but the reality is the statute is clear. It says that, within the first 15 days, if the landlord is not going to be making a claim from the security deposit, 15 days after you vacate the property is when he's supposed to give you the security deposit back. However, if he is going to make a claim on the security deposit, then he has 30 days to make the claim and send you the notice. So basically, in the statute, it's crystal clear in the statute, if you're a landlord, as to the actual language that you have to use in the letter to make the claim on a security deposit. So if you are a tenant that is expecting the security deposit back as soon as you vacate, technically by law, the landlord can hold on to it technically up to a month if he's going to go ahead and make a claim on the security deposit. And once again, if you're a tenant, I would recommend that you give the landlord the forwarding address. Okay, so there's not going to be any kind of delay or any kind of confusion as to where to send it, because the statute clearly states that if the landlord does not have the forwarding address of the tenant, okay, then he has to send it to the last known address of the tenant, which would be where he was living, at the time with the landlord. So basically, unless you forwarded your mail to that, unless you have forwarding in your mail or something like that, then it's going to go back to where you used to live, which is pretty much useless. So I would recommend that if you're a tenant and you want your security deposit back, that you absolutely give the forwarding address to the landlord so there's no confusion as to where it's supposed to go.
Very important. And one of the tips, I just had a case, I think it's a good idea for tenants when you're moving out to take some pictures, even a video, kind of showing the condition you're leaving the place. And here's a tip I just learned. I just saw a tenant do this. She took a video, walked us through the whole place. At the beginning of the video, she had a newspaper, and she showed the date on the newspaper to prove the exact day that it was being taken, and then gave us the tour. And I thought that was a clever little move to show exactly when it was being taken.
I have a question on that, Mr. Hittleman. I think it's important to invite the landlord to a walkthrough. invite them by email. And then if they say no, you can say, well, I wanted him to come or her to come and they chose not to. And also just to say that I do get a lot of responses to eviction saying, well, he has or she has, $2,000 of my money in the security deposit. That's not your last month's, that's not money that the landlord's required to, to apportion towards unpaid rent, so.
Definitely. Yeah, we see a lot of these issues that get solved at a walkthrough right before you moved out, and you have a conversation with the landlord at the apartment, and a lot of these issues do get solved. That's a great suggestion. So next question, we're going to start kind of general. I'm a tenant. I got the 3-day notice on my door. The 3 days have passed. I just got a knock, and a process server gave me the court eviction paperwork. Walk us through, what's this process? What's the timeline like at this point?
All right. Well, first, obviously, you come to your house, you get a 3-day notice. Okay. Whether it be posted or someone knocked on the door and served you the 3-day notice, you have 3 business days to basically respond to that 3-day notice, which would be to pay the rent. Okay. If the full rent that is claimed in the 3-day notice is not received by the landlord, then technically you're in breach of the contract. Okay. So now it's business days, and holidays are not included. Court holidays are not included. They should not be allowed in the 3-day notice. Okay. Next step is the landlord would file a lawsuit, and they have 2 possible ways. They file a lawsuit. They could have 2 counts. They could have the first count for just the eviction, removal of the tenant, and then they could have a second count if they want for actual damages, money that is owed. Now, most landlords, they just choose or opt for the first option because they want that person out of there if they haven't paid rent. They want them out of there as quick as possible. And basically, you get served with the paperwork after he files with my processor, after he files the complaint. After you get served, this is a summary procedure. So you have, as the tenant, 5 business days to make a response to this complaint. So by having 5 days to file a response, that's really almost no time. So basically, you have to immediately file a response. Now, the response could be a variety of reasons. It could be, oh, well, I sent him a notice and he never made repairs. But the number one thing is that the court is going to look for is that you put the money that is due and owing in the clerk's registry, in the court's registry. If you don't do that, then you waive all your defenses. So remember, within the 5 days of that happening, of you being served, you put the money in the court registry. You also have to file a response within that 5 days. Any response thereafter could potentially be stricken. After that, if you did file a response and you did put money into the court registry, the court will most likely order some sort of a hearing or mediation. Okay, it's resolved that mediation. But if it's not resolved that mediation, then the court's going to go to final hearing. So if it's uncontested as a landlord, you're looking at maybe this whole court ordeal being maybe 2-3 weeks, not including the sheriff coming out and serving the eviction. But if you're a landlord and there is a response, you're looking at a little bit of a longer of a period of time. However, don't lose faith in the system, because of the fact that as a landlord, the judge would most likely order that this tenant has to continue putting money into the court registry until there is a final hearing. So you don't lose faith in the system in that sense. So basically, if there is no contest to the landlord tenant, then you're looking 2 or 3 weeks. But if there is a contest, you don't have to worry, because like I said, they have to keep putting money into the court registry until this case comes to a conclusion. So it's technically a little bit open-ended, but uncontested, you're looking at 2 to 3 weeks.
Talking about that requirement to post the rent money into the court registry, perhaps, Judge, you could give us a view from the bench of how important that requirement is to your analysis. And, is that one of the most common reasons that an eviction is granted, failing to post rent into the court registry?
Well, absolutely, without a doubt. I mean, and it's so hard. I know that we're all in a very hard time right now. Rents are going up, wages are not, and it's really hard to make your rent. And when you do fall behind, I know that everyone wants to pay their rent, and falling behind usually means you don't have the money to pay the rent after you've gotten that 3-day notice that Basel was talking about. But unfortunately, the law in Florida is very strict. And even if you put all but $1 into the court registry, the law in Florida is that if you haven't put all of your unpaid rent into the registry, that I have to strike your answer and give the landlord a default. There have been cases where the judge ordered all the money into the registry by 5 o'clock on one day, and the tenant couldn't get it in until 8 o'clock the next morning. And the judge said, okay, that's good enough. You made your best efforts to comply. And the appellate court said, no, the landlord should have been given the default. So, I know some states are a lot more forgiving. If someone has a disability or they've got an unforeseen accident and they can't pay their rent, the law in some states is that the landlord has to, kind of help them along. Florida is not one of those states. So I would urge everyone to, when you get that summons, I know the last thing you want to do is read what it says. I'm sure nobody gets an eviction when life is going great. There's just no way about it. Everybody is in dire straits. But please, overcome that feeling and read the paperwork, because it does give you those time frames and tells you that you have to get the money into the clerk of courts registry. So it's not like you can't give it to the landlord. You have to come down to the courthouse, and you need to make sure that because I think you have to pay fees, right, Basil, on top of the back rent. So you don't just bring the amount of the rent, because you won't get it all in there. You have to find out how much extra, what do they take for your payment? They don't take a personal check. They only take, I think, certified checks, or I'm not sure exactly. But you have to make sure you do it right. And it's hard coming down here. You have to get yourself a parking space, figure out which one of the 3 buildings you need to be in. It's a lot down here now. So just be prepared and ready to get that done so that you can defend against the eviction.
Definitely. Thank you. We've talked about the law demanding repairs, security deposits, the eviction process. Let's talk about some very recent changes in the law. Broward County's new Fair Notice Ordinance, and how it provides protections for rent increases, terminations of month-to-month tenancies. Joe, tell us a little bit more about this new ordinance.
Sure. One of the things that the County Commission has been very concerned about in recent months is the complaints that they've received from various constituents about rental housing and the kind of transfer and increases in rent and the ability of people to find other places to live. And as the judge rightly points out, we do have an affordable housing crisis in Broward County, which means we do have a shortage of all kinds of housing, especially rental housing. So back in the beginning of the summer, the County Commission took action to adopt this new ordinance, which is a regulation in our County Code of Ordinances in Chapter 20 that deals with notifications to tenants and also deals with the Tenant Bill of Rights. So there are basically 4 parts to this. The first part is the notice of fair rent increases. The intent is to give a notification period that allows adequate time for tenants to relocate or for the landlord to find another tenant. And during this time, the landlord must give a written notice of 60 days before they increase any rent of more than 5%. During that time, the tenant has the opportunity to either accept or to compromise or to reject the increase and find somewhere else to live. And then after 60 days, the landlord can impose the increased rent and require the tenant to vacate. So this is not taking away any of the ability of a landlord to increase the rent. It's merely providing that increased period of notification for those increases of 5% or more. The second thing is the notification of termination on month-to-month leases. These are any kind of lease that is not of a specific duration. And in this case, the notice has to be 60 days before the end of the month. So the intent here again is to give tenants more opportunity to respond to the fact that their lease is coming to an end. There are certain exemptions in the ordinance for that, and I won't go through those in detail unless someone really wants me to, but there are certain tenancies that are exempted from that. The third part is late fees. The ordinance requires that landlords give written notice to the tenant either before they start a new tenancy agreement or before they assess the late fee. So that it's important that the written notice goes out each time there is a late fee, ahead of the late fee. And the intent here is to provide a factual basis for the late fee, to cite, any specific things in the rental agreement that justify the imposition of the late fee, to clearly explain how the late fee is going to be assessed and how it's going to continue to accrue. And we do have a sample on our webpage of a late fee notice. So I would offer that as something that if a landlord is looking for a way to do that, we've provided that. These regulations all supplement the notice provisions in section 8357 of the Florida statutes. They're not intended to provide any additional regulation. It is purely a supplemental notice requirement. And then the fourth thing is the Tenant Bill of Rights. And this basically is a document that provides information on rental housing rights and resources. Particularly, it notes that units have to be fit for habitation. It references fair housing and discrimination. It explains some information about how to challenge evictions and resources that are available with some of the names of agencies and phone numbers. And the important thing to know here is that the new ordinance at the county commission level requires that all landlords give this document to their tenants, either ahead of signing a new occupancy rental agreement or at the time of renewal of an existing lease. And we do have this on our webpage in 3 languages, English, Spanish, and Creole. And we ask that the landlords retain a signed copy after the tenants have received this for at least a year, so they can provide evidence that they complied with the ordinance.
A lot of changes over the last few months. Basel, let's talk about some of the issues we're seeing with the new law. First, in calculating the 60 days, this is a question we're getting a lot. How do you calculate the 60 days in the 60 days notice?
Sorry, I was muted. In the spirit of the actual statute for the state of Florida, state of Florida statute says that it's a 15-day notice that has to be sent, but it has to be sent prior to 15 days prior to when the rent was due. So if the rent was due on the 1st of the month, that means you have to send it 15 days prior to that. Now, in the spirit of the actual statute, in this situation, if it's going to be a 60-day notice that has to be sent, it has to be sent 60 days prior to when the rent is due. So once again, if it's due on the 1st of the month, then it has to be sent 60 days prior to that period of when the rent is due. Basically, if you don't calculate it like that, I've seen a lot of landlords say, oh, well, I sent a 60-day notice, but it wasn't sent during the proper time period. So in the spirit of the statute, I tell my landlords, you have to send it 60 days prior to when that due date period is for the rent.
And Basel, in terms of the Bill of Rights, have you been seeing all landlords giving these out to new tenants, or do you think there's a learning curve and everyone's catching on that this is a new process?
There's definitely a learning curve. However, I understand that the Bill of Rights has to be there, but I haven't seen any kind of repercussions from the courts or any kind of problems, if they didn't give it to them. So I have yet to see anything where, the court has said anything that it hasn't been attached or what have you.
Are you encouraging your landlords to do it?
Absolutely.
So if I could add to that, I think that the fact that this is very new is part of the problem. I mean, we are still very much in an educational program at this time. We're trying to get the word out to as many landlords and to tenants to make them aware of this. We, in fact, even have these posters. I can show my poster here. Oh, that doesn't show very well. Oh, you may see these beautiful posters posted around Broward County, which advertise our webpage and provide information to, basically link to those links that I referenced to on our planning renters webpage. So,
Joe, I know this is new. These are recent changes. Any statistics, any information that the county's gathered yet on how these changes have made an impact?
well, I don't have any statistics on the changes yet because it is so very new, but I do have some numbers that I can share on rental housing and how important rental housing is in our community. Somewhere around 260,000 rental units in Broward County, which makes up more than 2/3 of our rental housing stock, and more than a third of our rental housing stock, excuse me, which means we have about 713,000 residents that are living in rental housing. And our rental housing stock is not just apartments. I mean, it's everything from high-rise apartments all the way through to single-family houses and duplexes. And so there is a full range of housing there. We've seen, rents jump significantly in Broward County. Between February of 21 and 22, there was a 30% increase in average rents in Broward County. I mean, think about that. And not many people are getting 30% wage increases. 30% is a lot. And that was partly what triggered the Board of County Commissioners to initiate this ordinance change. Right now we're seeing, average monthly rents are about $2,500. And, that ranges from $2,100 for an efficiency unit up to around $3,300 for a 3-bedroom unit. And of course, 3-bedroom units are families. Many times families with children. Renter households typically are more vulnerable. They tend to have lower wage rates. They tend to have households where they're spending more than 30% of their income on housing. And when you're spending more than 30% of your income, that's when you are cost burdened. And that's really part of the affordable housing crisis that, the County Commission is trying to address.
And I'm sure they have less saved so that if they do have a problem, they're living month to month. Isn't that right?
Yeah, that's definitely the case. I mean, we're talking about a lot of service level jobs. We're talking about retail jobs, and we're not always talking about people who are not employed. I mean, that seems to be a common thing. People think of, folks who don't have jobs as being the people that need affordable housing. But the reality is you have many people who are working multiple jobs just to make ends meet. And when you spend more than 30% of your income on housing, that's taking away income that could be spent on other things and that needs to be spent on other things, including having the ability to save money. So you're absolutely right, Judge.
Joe, I have a question. How has this affected the landlord and tenant as far as the landlord demanding, say, a higher security deposit or what have you? Because now instead of raising the rent in 15 days, he's going to say, well, if I send a 60-day notice, most likely I'm not going to get paid during that 60-day time period because they're going to vacate. So I'm going to increase the security deposit, or maybe I didn't request a last month's rent before, but I'm going to request it now. Have you seen any kind of changes statistically in that?
I haven't seen those changes yet, but as I said, this is very new. I mean, the ordinance was adopted in May, but many parts of it didn't become effective until September. So we really are at the cusp of this and not having had the opportunity to see those changes and the impact of those changes yet.
Joe, we've all agreed. One thing I think we can all agree on, there is an affordable housing crisis It's not an exaggeration. The word crisis is accurate. And we did want to share a resource for people who are behind on the rent. Broward County does have an emergency rental assistance program. It's a program you can apply online for. I'm going to put the link to the portal in the chat. And if you're behind on the rent, this is a worthwhile resource to look into. Jill, any further information on that, or is that, I think that's run by a different human.
Yeah, that is being run through our human resources, human services department, and I believe they are currently accepting applications. There was a time period when they got a little overwhelmed and had to close the window, but I do believe it's been reopened. And so this website is definitely the best resource for that.
Excellent.
Can I say something about that real quick, Mr.
Yes,
Hittleman?
please.
I can't tell you the number of responses to evictions that I receive where the tenant indicates that they have applied for assistance. And unfortunately, this kind of goes back to what I was saying earlier about the stringency of Florida law in terms of making sure that unpaid rent is paid into the registry. Back when we were receiving COVID funds, the CDC had issued an emergency moratorium on evictions. However, the United States Supreme Court overturned that ruling or that edict from the CDC, and I am without authority to allow a tenant to continue to fight an eviction or remain in possession of a property because they've applied for assistance. So I guess, and you know, I guess my point there is, please apply as soon as you think you're going to have an issue, and please continue to request the assistance, request information on the progress of your application, because unfortunately, the fact that you applied is not a legal reason for the tenant not to place the money in the registry. Unfortunately.
Yeah, that's a great point. We've seen a lot of cases like that where, you know, the tenant waits till they're actually served with the eviction case to apply for the rent assistance. And at that point, they have 5 business days to respond. And it's just, it creates a real crunch for the whole system. So yeah, apply early. That's a great advice.
And Broward's not the only assistance program. Different cities have opportunities. Is that what you were going to say, Basil? I'm sorry if I interrupted you.
No, Your Honor. I actually had a question. We brought this up actually in our conference last week. Basically, a landlord's not allowed to discriminate against any kind of source of income, legal source of income in Broward County. So you may apply for this assistance, but a lot of these situations require the landlord to cooperate. So, you know, just to let everybody know, Broward County and I think Miami-Dade County are the only 2 counties, I think, in the state. I'm not sure. I have to get updated on that. That basically say you cannot discriminate for legal sources of income. And if this is basically a way in which you're paying rent, as long as you're not late, but if this is a way in which you're paying rent, then technically your landlord cannot say no to you.
Right.
Great point. And yeah, Broward is one of the very few counties in the state to have that source of income protection. Speaking of protections, there is one more law that I want to talk about before we ask our panelists for their final thoughts on the housing world. You may know that October is Domestic Violence Awareness Month, and Congress recently reauthorized the Violence Against Women Act, and the VAWA, the Violence Against Women Act, does provide protections for certain people in federally subsidized housing. So that's the big key. If you're a tenant in federally subsidized housing, so that's Section 8, or sometime a federally program is paying your rent, provides protections for victims of domestic violence. And the major protections are you can't be denied because you've been a victim, can't be denied admission. You can't be evicted because you've been a victim. You know, we've seen some cases where, we've seen ones where the victim there's an eviction filed because they called the police, and a big police response had to come out to protect them. So there's protections for that. And same goes, you can't be denied your federal assistance because you've been a victim of domestic violence. So that's an important protection for victims of domestic violence and federally subsidized housing. And it was just reauthorized. So it is current and on the books. Before we wrap up and give the CLE number, let's give the CLE number now. We won't make them wait till the end or make sure we don't miss it. We're going to put the CLE in the chat, and the CLE number is 2208755N. Again, 2208755N. We've learned so much about housing today, the law, the changes, resources, forms. If each of us could share a final thought, we'll start with Basel, just a final thought for everyone watching.
The final thought is basically, if you're a tenant or if you're a landlord, keep the lines of communication open with each other. And the reason why I say that is because I think both sides really want this landlord tenancy to succeed. I think both sides don't want to end up in court. So I always recommend to my clients, leave the lines of communication open. So if the tenant is having a little bit of an issue with making rent, it's always a few days late. No need to immediately serve with that 3-day notice. At the same time, though, I understand the landlord's responsibility. He has to pay a mortgage. He has to pay insurance. So yes, he probably needs that money. But I think if they leave the lines of communication open, then I think, that will probably save everybody headache and time, and everybody come to an understanding, and we won't have to resort to the courts for evictions or a resolution of anything. Just always keep the lines of communication open, and I think that would be the best option for both sides.
Well said. Joe.
Well, I think, representing the county, we understand that rental housing is really important in our community, and that it's important that there's good communication between landlords and tenants, and that tenants understand the rights and resources that are available to them. And that is why, we've put together the website and why we are trying to implement this ordinance and provide more information to the community.
Judge Benson.
Well, I would just like to, give a Purple Heart to tenants, landlords, the eviction bar. It's a hard time. It's just a really hard time to be in any one of those capacities and to maintain your patience and decorum. I salute all of you. And I would also say to both tenants and landlords, please document things. In this age, email, screenshots. I'm going to show my age now. I know all the things you call it. But, it's really important for the court to be able to review and piece together, what happened and what the issues were, and whether or not the landlord was informed or the tenant was informed. So please document things. Just make yourself a file, and hopefully we'll get through this. I'm hoping that we're going to have we're going to get to the other side of this horrible housing shortage and be able to provide housing that's, clean and affordable to our people. And also hope that our landlords are able to pay their bills. I know it's tough on both sides.
Thank you again to our panel, providing a variety of perspective on the housing world. Thank you so much for watching. We hope you learned. We hope you learned a lot this afternoon. Stay tuned to our Coast to Coast Legal Aid of South Florida Facebook page for future events and clinics, and hope everyone has a nice afternoon.